Thank you, Molly, for a very kind and very complete introduction. So we're going to talk today about posthumous conception in Australia and look at various legal and ethical considerations. It's not a complete talk, but it will give you some ideas to what is actually involved. And this is something that we do through the public fertility service as well as in private on occasion. So let's start with that. I just need to work out how to, here we go. So we'll look at the technical aspects of it very, very briefly as to what advances in reproductive technology allowed posthumous reproduction to take place. And we'll look at various scenarios. In fact, there is only really one scenario where this is practiced at the moment. And then we will look at various ethical and legal challenges associated with this. So the definition in the olden days, it used to be that posthumous reproduction was defined as a birth of a child after one of the biological parents was no longer alive. And that was common throughout history, where men went to war and died and their wives were left behind. They were pregnant at the time, and then the child was born after the father was dead. But in the past probably 20-25 years, the definition changed. It usually means conception or pregnancy after one of the parents has died. And this is only possible because of the advances in IVF and gamete freezing. So IVF allows for conception to take place in a dish, obviously, and freezing of sperm and occasionally eggs, but not that often. You can have gametes frozen and the patient who produced the gametes, who provided these gametes, has died, and you can still use those gametes like sperm and egg to achieve pregnancy. And so the scenario that is common, this is what we see maybe 5 to 10 times a year, is that a male partner dies suddenly. And it's often a car accident. It could be suicide. It could be an industrial accident. And this male partner is part of a couple, and they're trying to achieve pregnancy, to conceive a baby. And the female partner, or usually member of the family, but usually female partner, approaches the fertility service, either private or public, requesting for sperm to be harvested. And what is quite fascinating to me is that we can get viable sperm for up to 5 days after male's death, probably up to 7 days, but sooner the better, obviously. And so we get a phone call to say, could you please do this? We go through all the protocols that we have for these sort of eventualities. And one of the consultants, it used to be myself, but now it's more junior consultants, would go to where the body is. And often it's the coroner's court where the body is stored, or the morgue in the hospital where they died. And we would take a sperm sample. And that technically is quite easy. You essentially, open the testicle, take a sample, a good sample, and straight away put it in a solution and take it to a lab where embryologists would look at it, usually find viable sperm that is either moving or not, but it doesn't really matter, and they freeze it. And usually there is quite a lot of sperm frozen from these samples because the samples are, quite big. And then this sperm later on can be used to create embryos with eggs usually from the surviving female partner. Occasionally, sudden death of a male partner takes place in couples where they are already going through IVF. And this is a very different scenario from the legal and ethical point of view. And I'll tell you why. This is a crucial distinction. So couples who go through IVF, in Victoria at least, are required to undergo counseling. And that counseling, it's not sort of touchy-feely sort of counseling, it's the counseling to go through all the possible scenarios that could happen. For example, the counselors would speak with the couple about what would happen if one of the partners died, or if they get divorced, what would happen to the gametes and the embryos? And part of the consent for IVF has a little tick box as to whether the partner would allow for their gametes or embryos to be used by the surviving partner in case of the untimely demise. And usually people tick yes. And if we have that written instruction, well, there are no issues. There are no legal issues. There may be some ethical issues, but legally we can proceed with treatment under Victorian legislation if there is some sort of advanced directive from the deceased partner. If there is no advanced directive, so if someone dies, they were not doing IVF, they were not trying to get pregnant through IVF, they were just trying to get pregnant naturally, then there are all sorts of legal and ethical issues that arise, and that will be what this talk will be mostly about. So from a medical legal point of view, there are 3 stages in this. There is retrieval and harvest of sperm, which has its own sort of legal framework. There is storage of sperm, that's also quite heavily regulated. And then there is the use of sperm from a deceased partner to create embryos and attempt pregnancy. And all of those things are very tightly regulated in Australia in most states, but not all. And so the framework in Australia is variable from state to state. So every state has its own legislation that guides these processes, and that creates unequal access to certain treatments due to specific rules that are unique in every state. And this is certainly true for posthumous reproduction because, as we will see later, some states have regulated that aspect of fertility treatment and others have not. And so in terms of storage, that's the first step. That is guided by Section 27 of the Human Tissue Act. And it provides conditions for tissue removal from deceased individuals. And this is not specific to sperm or eggs or gametes in general. This applies to any tissue that someone, for whatever reason, might want to retrieve from a dead body. And the conditions are that it has to be done for therapeutic, medical, or scientific purposes. So you can't just come in and take a kidney just because you want one. It has to be done for these specific purposes, therapeutic, medical, or scientific. And generally speaking, there has to be at least no known objections from a deceased individual. And in terms of organ donation, there should be no objections. And in fact, it needs a positive consent from the surviving, usually next of kin, but all other members of the family must agree. Otherwise, it's problematic and it needs to go to arbitration. It needs to go through the court to decide what to do. If, for example, one family member wants for organs to be donated, but others do not, it becomes very tricky occasionally. And even if the deceased has advanced directive in terms of organ donation, there is always some leeway if the relatives object. And so in terms of sperm retrieval, you really need to have authorization from the medical officer who is involved or from the coroner. And that involves for them to say, we're happy for you to do it. They don't have to investigate anything as long as they don't know any objections from anybody who is surviving. They can authorize removal of sperm. And usually, in terms of future use, we would request, and it's part of the act, for a couple of people to say, yes, this couple was, trying to get pregnant, and this is something that the deceased wanted, right? There must be no objections. If someone is objecting, we probably shouldn't be doing it because that would make it a little bit tricky. And very, very occasionally, these things end up in court because someone needs to make a decision, and it can be family members if there is conflict. So usually everybody agrees, the next of kin or the surviving partner wants it done. We would speak with the authorized medical officer if it happens in hospital, or to the coroner to say, do you have any objections? They would say, no, we're happy for you to come and collect sperm. And then someone like myself would come in and do the retrieval. There were some cases where people didn't sort of know what the legal situation is. And on occasion in New South Wales and Victoria, these things ended up in court. You do not need a court authorization to retrieve sperm, but some of the cases did end up there. And the court said, look, you know, sperm retrieval is clearly for medical, therapeutic, or scientific purposes. So that is absolutely allowed after the Human Tissue Act. All you need is the authorization of the medical officer, authorized medical officer, and no known objections. And then the retrieval can be done. Now, in terms of storage, there are some regulations, and it's probably mostly true for Victoria. Now, from a scientific point of view, a frozen sample can be stored indefinitely. It is completely inert, and you can put it in liquid nitrogen and leave it there for 30 years, and then you defrost it, and it's as good as new. So there is no sort of expiry date on these things, but there are some limitations in the Victorian legislation. For example, gametes and embryos can be stored for up to 5 years, and then it's relatively simple process to get an extension for another 5. But after that, it becomes a little bit problematic. You actually need to seek permission from VARTA at the moment, or even a court order to extend storage. And we encounter this on occasion when very young people freeze their gametes. For example, a young girl, 18, about to go through chemotherapy for Hodgkin's lymphoma, for example. We collect eggs, we freeze them, but they can only be stored legally in Victoria for about 10 years. And after that, some sort of review needs to take place to extend the storage. Stored gametes can be used for IVF. So with thaw sperm, we can use it to put it inside an egg and create embryos. But they can also be transported in a cryopreserved state to a different jurisdiction. And this is very important because some things are allowed in some states, but not in other states. And that's a crucial distinction, really. Everything about this is very highly regulated, especially in Victoria. So both IVF and removing gametes from Victorian jurisdiction to send it somewhere else, either another state or overseas, they are very highly regulated. So in Australia, some states, in fact, the majority of states, are what's called legislated states. So they have an act, and in Victoria it's called an ART Act, Assisted Reproduction Treatment Act, which regulates what can and cannot be done in terms of IVF treatment and what the conditions are to access that treatment. You might have heard that in the past, part of that act was that everybody who has IVF needed to have police checks. Thankfully, that was removed, and we don't have to check if someone is a criminal before they can access IVF. But nevertheless, in New South Wales, Victoria, South Australia, and Western Australia, there are specific laws that guide actual conduct of IVF clinics. Now, there are also unregulated states, and not surprisingly, it's Queensland, as well as ACT, Northern Territory, and Tasmania, where there is no equivalent of ART Act. And in those states, they must be guided by Commonwealth legislation, which is not as exhaustive as the state acts, and also national therapeutic guidelines from NHMRC. So this case is important because this sort of demonstrates what the pathway is for sperm or gametes in general to be used without written consent. So Mrs. and Mr. Edwards were married and planning to have children, and it was known to the family and the friends that they're trying to achieve pregnancy. And unfortunately, Mr. Edwards had a significant industrial accident and he died suddenly while they were trying to get pregnant. And a request was made to a clinic in I believe it was in Victoria, but it could have been in New South Wales, to retrieve his sperm, which was done. And it was retrieved, it was frozen, but unfortunately there were issues with how this sperm can be used. Now, the Victorian Act, and there is a similar act with similar provisions in the New South Wales, in Part 5, it deals specifically with posthumous use of gametes. And Section 46 specifically says that a gamete cannot be used for the purpose of reproduction, for the purpose of creating an embryo and achieving a pregnancy, unless there is a written, it's actually specified in the Act, written consent of the deceased. And of course, unless the couple is going through IVF, that is not available. It's as simple as that. So Mrs. Edwards had to go to Supreme Court of Victoria and to say, I have sperm frozen. This is from my deceased husband. I would like to use it, but the Victorian legislation specifically prohibits me from doing so because there is no written consent from the deceased. And so any use is prohibited, and that includes reproductive purposes, but it also includes taking the sperm to a different jurisdiction. So a clinic cannot authorize transfer of these gametes unless there is written consent to a different jurisdiction where this is allowed. And so the question before the judge was, how can we, legally allow for this sperm that is frozen without written consent to be transported to a jurisdiction where posthumous reproduction is actually not prohibited? In those states where there is no legislation guiding IVF services, the unregulated states, they rely on NHMRC guidelines. And it is a legislative requirement that all clinics must comply with NHMRC guidelines to retain their registration with ARTEC, which is the regulator of IVF clinics. And so you have to abide by those rules. And in those rules, it actually says, the Section 822(3), it says that you can use gametes from a deceased person. It can only be used by the spouse or the partner, and this is important. So you can't use it for, you can't donate it, you can't use it for some random person, you have to use it for the next of kin or the partner of the deceased. And there have to be some evidence that the deceased person would have supported such use. And that's where those statutory declarations from two people who know the deceased would come in handy, because that sort of clears the way for the sperm that is frozen to be used. And essentially what it says is that in the absence of clear provision, posthumous reproduction is allowed in states where there is no legislation that prohibits it. So that's what clinics rely upon in the unregulated states. And as I said, it's Queensland, ACT, and a couple of others. Now, the judge in the Edwards case had a bit of a problem because the legislation in Victoria is very clear. you can't misinterpret it. It clearly states written consent is required for any use, and that would include transferring gametes to a different jurisdiction. And what the judge did is to consider whether human tissue, or specifically sperm, can be thought of or have some qualities that would make it property, with property rights, so sort of part of the deceased estate, whether the surviving partner, Mrs. Edwards in this case, would have property rights over the sperm that is stored. Does it belong to her? And if the property rights can be attached to sperm, then she would have every right to take it and do whatever she wants with it, even though she can't use it in Victoria to try to achieve pregnancy, but she can take it and move it to a different jurisdiction where this is allowed. And it's a fascinating story because the judge eventually granted permission for Mrs. Edwards to transfer sperm, I believe, in this particular case, and when it went to ACT, to Australian, to Canberra, to one of the clinics in Canberra, and I believe that she actually had a child from this. But the whole case revolves around a high court case that was decided in 1908. Which I find absolutely fascinating. So I'll go through it a little bit. I know we were a bit short on time, but it's very interesting. So this is the case that was decided in 1908. And that's the name of it. In English law, dead human beings, as well as live human beings, they cannot be property. So corpse cannot be subject to property rights and has no honor. And this case was really very, very interesting. You should look it up if you can. There was a two-headed baby born many, many years ago. It was probably in the 1880s or 1890s. And they were clearly Siamese twins. And the obstetrician who delivered these twins, they were born dead. He thought it was interesting and fascinating and essentially put it in a jar with formalin and kept it in his practice for years and years and years. And then he died and his estate was auctioned off. And someone bought that two-headed baby in a jar and decided to make a business out of it. So this person exhibited this jar with two-headed baby in various fairs around the country. And one day, a police officer named Spence, I believe it was Spence, and the guy who, the owner of the two-headed baby was Woodward. Anyway, Officer Spence was walking down the fair in the local town, and he saw the two-headed baby, and he was really upset about it. He was really not very happy. He thought it's terrible, to exhibit the baby in a jar. So he confiscated it. He said, this is not allowed. You can't have a two-headed baby on display. And interestingly, this case and the other guy, he really wanted it back because that was his business. That was, his source of his livelihood. And so Woodward took him to court saying, I want this two-headed baby back. And it made its way all the way to the High Court. And they looked at it. And the judges at the time thought that, yes, human tissue, human corpse, two-headed baby cannot be considered property. But if there is work and skill applied to it, and that's what they framed it as, work and skill. If work and skill was applied to human tissue, it can potentially gain some property rights. So it can belong to someone. And this was unique, and it was unique until very recently. Recently, this case was cited in English case that sort of took similar approach. Tissue, human body parts, these sort of things in Australia, based on common law, based on this case, can be considered property of someone if work and skill is applied to it. And so clearly retrieving sperm and freezing sperm fulfills that criteria. There was some skill and work applied to the sample. And so the judge in the Edwards case essentially said, look, based on this precedent, clearly this sperm can be considered property. The next question is, who does it belong to? And obviously it belongs to the next of kin or the surviving partner, and therefore she can take it and, you know, transport it to a different jurisdiction where posthumous reproduction is possible. And so as the result, this is what it looks like at the moment. So retrieval of sperm after death is permissible as long as there are no objections in all jurisdictions in Australia. Storage of sperm with some limitations is also permissible in all jurisdictions, in all states. The use of sperm is specifically prohibited in legislated states. So in Victoria and New South Wales, for example, you can't use it. But in unlegislated states, based on the NHMRC guidelines, the use of sperm without written consent of the deceased is actually allowed based on NHMRC guidelines. And so the path to trying to use that sperm to achieve pregnancy or to create embryos is, in Victoria at least, unfortunately, every case has to go through the process. And so a widow usually would have to take this to Supreme Court for a hearing. They would look at the previous cases, and the judge would say, yes, based on the Edwards and the High Court decision, this sample belongs to the surviving partner, and therefore she has permission to transport it. And then the clinic in Victoria would send it cryopreserved to a different clinic, usually ACT or Queensland, and then the deceased partner can, the surviving partner rather, they can use it to try to create embryos. So that's in a nutshell how it works in Australia and the differences between different states. We'll talk a little bit at the end about the rights, and obviously it's a tricky situation because there are multiple rights and interests involved. There is the surviving partner, for example, Mrs. Edwards, who really wants to have a baby. The potential child and the right of the potential children is, in legislation, it says whenever you do IVF, you have to consider the interests of potential child as the paramount consideration. It doesn't actually specify what that means, but that needs to be considered. And you have to take into account the rights of the deceased and whether any rights in fact survive after someone dies. And there are two somewhat conflicting theories on this, and that's a will theory and interest theory. But first we'll look at the rights of the child. So the welfare of the child is a paramount consideration. There are legal and ethical guidelines which all IVF centers must follow, and then there are Commonwealth legislation and Commonwealth guidelines where the first priority in any fertility treatment is the well-being of the future child. When you look at the literature, there used to be some pushback for example, single women accessing IVF because the concern was that there is some sort of detriment to the child being raised in a one-parent household, but that doesn't seem to be the case. There is quite a lot of work that was done recently and in the past where the children of single parents are as balanced and psychologically normal as children with two parents households. But there may be some unique psychological risks for posthumously conceived children, and we simply don't know what they are. It's difficult to do research on these things because this is not a common scenario. The rights of the dead are quite fascinating. Do dead people actually have rights? And we upkeep donation, organ donation requests, burial preferences, and wills. But generally speaking, in English law, once you die, your rights are gone. You don't have any more rights. The only right you have as a dead person is to be buried. That's what it is. And even those things like burial preferences, wills, and donation requests are commonly challenged. There is this question of reproductive autonomy after death, whether it survives death. And as usually is the case, most judges would approach this from the best interests of someone. But it is difficult because what is the interest of a dead person? I mean, do they really care if they have a child or not? But one of the sort of fallbacks is that surviving family members say, look, this person would not have objected. And if someone comes up and says, look, they would have, then posthumous reproduction would probably not be allowed. The will theory is the right-based theory and capacity to make choices. That people can't make choices. But this theory is not the best because obviously some people also cannot make choices. It doesn't mean that they don't have rights. And the opposite theory is the interest theory, where you focus on protecting individual interests, and it can incorporate the interests and rights of the deceased, but the question then arises, what are those interests and rights? And of course, reproductive autonomy is, as always, a primary consideration. And that's why a valid written consent is so important, because if that exists, then we know what the deceased would have wanted. Otherwise, we really can't tell. We can only speculate. And so there is a necessity for clear consent or objections to posthumous reproduction, preferably from the deceased, but if not, at least from the group of family and friends who would know what that person would have wanted if they were alive. And the ethical consideration are the rights of the living versus the rights of the dead. Very important to ensure child welfare, and there are some undertones of culture, religious and social beliefs, and there is always a balance between science, law, and mortality. I mean, we can do a lot of things, but always the question is, should we do those things or not? And it's especially true in this area, in fertility area, in reproduction area. And so this is essentially the protocol that we use. If someone approaches us to do this, we need written documentation. The retrieval will only proceed if the request is made by the surviving partner or a wife. We would prefer to retrieve sperm as soon as possible, but within 5 days is probably fine. I mean, we've done it up to 7 days and it still works. We need consent from the authorizing medical officer if the death happens in a hospital, or the coroner, and it's a verbal consent. We don't need to have any paperwork. We would prefer to have a couple of statutory declarations from someone else other than the partner to say that this person wouldn't have objected or was trying to achieve pregnancy. And if we have these documents, we would go and retrieve sperm, store it, and have a chat with the surviving partner to say, you can't use it in Victoria, but this is the path for you to go to court and perhaps get the sample in a frozen state moved to a different jurisdiction. This has other implications. For example, I was involved in a paper where we looked at fertility preservation, where someone was about to die from cancer or something else, whether they're conscious or not. So that has undertones that need to be considered in those situations. If we know that someone is dying, should we really offer fertility preservation in those situations? And there are unique concerns in those scenarios for single and same-sex couples, which are interesting, and you can certainly read about it. The second paper on the screen deals specifically with fertility preservation in oncology patients with poor prognosis. And of course, you know, poor prognosis in this setting means they'll probably die, and then posthumous reproduction will need to be considered. And the talk is mostly based on the first paper, and that was published in the British Medico-Legal Journal. And if you wanted to read it, there is a lot more information in it, and it has quite a lot of case law involved, which I only addressed superficially. I think that's it for me.